So thank you everybody for being here. I'm very happy to welcome you to this new workshop of the Moebius project that is working on sovereignty, migration and borders, looking at Europe in particular, in order to look at the hiatus, to look at the gap between ethics and uses of states. And this workshop is focused on the thickness of borders. And the thickness of borders has been widely studied by geographers. These scholars underscore that borders are not anymore one-dimensional line between dyads. Now, borders are more multidimensional areas opposed to migrants. And I think that the idea of the thickness of borders has not been fully exploited by other disciplines, even though sociologists embrace the topic. Lawyers didn't so much. This is, of course, the purpose of this workshop, that will create discussions between sociology, political science, and law in order to see how thick the European borders are. Diverse approaches will consider today the width of EU external borders, borders that tend to expand outside the territory of European member states. This is the externalisation process, and that extend them inside the territory. This is the internalisation process. So the borders constitute large spatial spaces which enfold migrants in networks beyond and below the territorial state limits of European countries. And there are also long temporal phases which impose upon migrants an immersion in a temporality that is both dilated and suspended. So this is the way we are going to look at the thickness of European borders, thanks of the presentation of 4 tremendous speakers. We will have the great honor to welcome Giuseppe Campesi, who is Professor of Law and Society at the University of Bari. We will have the pleasure to hear Violetta Moreno-Lax, who is Professor of Law at Queen Mary University London, at the University of Barcelona, and now Director of the RT School in Berlin. Afterwards, we will listen to Maria Gega, who is lecturer of law at the University of Rouen, and finally Paolo Ciuttita, who is sociologist and researcher at the University of Genova and also at the University of Sorbonne Paris Nord. So I'm not going to take the floor more. I'm just giving now the microphone to Giuseppe, because he's going to present us how there is a redefinition of the legal geography of EU borders nowadays. So, dear Giuseppe, the floor is yours. Thank you.
Thank you, Marie-Laure. Good afternoon to everyone. I hope you can hear me well with my headphones.
We can hear you well, do not worry.
Okay, great. What I'm going to present today, it's well, the part of research I'm trying to carry out on the legal geography EU it's an ongoing project. It is something I have already the opportunity to present in part, at least last April, in the talk we had together. So I'm going to repeat some, then try to expand my reasoning and my presentation a bit more, trying to focus to some of the implications of the EU Pact on Migration and Asylum for the way in which borders are configured at the EU level. My starting point was an attempt to going beyond the literature on dematerialization of borders. There have been a huge debate in social political sciences, in geography, on these idea that borders were increasingly dematerialized. And so my impression, and also the starting point of my reflection, was that in some way it was easier to identify the different signs of crisis of the old Westphalian border regime than to discern, to identify the defining features of the new morphology of borders. It's why more easier, you know, to describe a crisis of a regime than to identify what are the new features of the new border regime. So my starting point is that borders have not simply been relocated everywhere, but that they have been reconstructed with enforcement methods in specific strategic locations. So in many ways, I felt the need not to lose sight of the specific geographical materiality of the border. So the idea was that deterritorialization and re-territorialization go hand in hand in the transformation of border control practices. So what I tried to do is to highlight how states are transforming and redefining their border capabilities. And I took these concept from Saskia Sassen, actually, to refer to the state technical capacity to manipulate the morphology of the borders by reshaping certain components of the Westphalian border regime in response, of course, to the changing function of borders. But I was interested not just in the infrastructural capacity to redefine borders, but also in the legal dimension of borders. So, in the way in which law is used as a technical tool to reshape and manipulate borders. So, when I talk about a technical capacity, or infrastructural dimension of borders, I'm specifically referring to law as an infrastructure, as a tool to reshaping and manipulating the border. So in order to develop my analysis, I've tried to lay down my methodological foundation by reflecting on the essential elements of a geographical approach to the study of law. I'm not going into many details here on my to the geography of law. Just briefly, I would say that, you know, my idea is to try to understand the recursive relationships between law and space. So try to understand the role that a law has and can play as an instrument of spatial organization of the human behavior, but also the idea is that also social practices of spatial engagement, the use of space, have an influence on legal categories. So this is actually my key theoretical and methodological theoretical assumptions, and also methodological approach when I study borders from a legal, a geographical and then I've tried to identify what I consider as the key, or the three key geostrategies of the current EU border regime, with a focus, of course, on the legal innovations that have been necessary to produce these three geostrategies and to ensure their functioning. When I speak about geostrategies, or I use the term geostrategy, I'm taking a concept which has been used in the international relation theory, in particular by William Walters and Browning and Genemi. And so the idea is that the spatiality of borders can be organized in different ways, depending on the object of the game, the function that borders should pursue. So we can identify different geostrategies, so different approaches to the governance of human mobility, and these different geostrategies can and are actually combined and produce what can be considered as the contemporary regime for the control of human mobility, or contemporary border regime, if you want. So the three geostrategy I have identified are the geostrategy of the nodes, the geostrategy of the zones, and the geostrategy of the walls or fences. I will say something on these three different geostrategies, on each of them. On which point of view the EU Pact has an impact on in many ways reinforces the logic of the three geostrategies I have just mentioned. So from the first point of view, starting with the geostrategy of nodes, we can fairly say that actually the most significant part of border enforcement efforts are carried out at border crossing points. It is through border crossing points which the vast majority of cross-border movements are actually channeled. And therefore, border crossing key nodes, so the key point of interconnection in the global mobility infrastructure. So the large part of the efforts at controlling undesirable mobility consists in controlling the access to the global mobility infrastructure, and this access is controlled, is governed through by using a range of technical, ranging from studies, screening and profiling technologies. So we all are well aware of the fact that the literature on the digitalization of borders is huge, is immense. A problem that I have with this literature is that it places too much emphasis on the idea of the dematerialization or deterritorialization of borders. According to my opinion, and I'm taking here the point of view also expressed by many political geographers, according to this point of view, even digital borders have a strong spatial anchoring. The digital borders have an anchoring in the key interconnection points of the global mobility infrastructure. It is in these places where data are actually extracted from individuals, and it is in these places, especially at border crossing points, that abstract risk profiles meet their bodily counterparts, and so the intersecting with the mobility path of real individuals. So we don't have to forget the role, the key strategic border crossing points are as a point of interconnection in the global mobility infrastructure, has as an actual place of border in enforcement, and as an actual special anchoring for the infrastructure of borders. Moving now to the second geostrategy, the geostrategy of border zones. I will start from the definition of border surveillance included in the Schengen border code. We all know that border surveillance is defined as the activity which is directed at preventing and discouraging persons from circumventing the checks at border crossing points. So if we take this definition of border surveillance, we clearly see that the geography of border surveillance, as it is defined in the Schengen Border Code, seems too hard back to the classic Westphalian geopolitical imaginary. So there is an apparent continuity with the classic border regime, but this continuity masks the fact that there are many geostrategic innovation associated with the contemporary border surveillance strategies. And we are all well aware of the fact that destination countries try to see and legal migration control by destabilizing the territorial fixity of the Westphalian border regime, of the Westphalian classic idea of linear borders. They project outward, creating migratory movements, but they also retract borders inward when migrants are able, in a way or another, to reach the state's territory. And this is done by establishing differentiated legal regimes in certain strategic sections of the territory. So the effects of these strategies are well documented. Basically, in fact, destination countries are in this way able to elude their legal responsibility and sidestepping the legal guarantees and protections. And so apparently, there is the temptation to describe these zones, this area of legal exceptionality, as a space of legal void or legal suspension or legal exception or legal black holes, if you want, where individuals are exposed to the absolute power of the state. I find these interpretation problematic in many ways, because the risk here is to obscure the role that law actually plays in the actual production of these border zones. And in fact, the legal instruments are mobilized to cooperate with third countries. And very often border zones are actually the byproduct of the uncertainties and fragmentation of the legal framework, and the state, or the states in general, strategically exploit legal fragmentation here. And finally, in many cases, the border zones are actually produced by actively manipulating space, the territory, legally manipulating the space and the territory, trying to read the relationship between territory, sovereignty, and rights. So again, here there is a crucial role that law actually plays in the production of the border zone. So describing border areas or border zones as space of legal void is runs the risk of not seeing or not addressing the role that the law actually plays in the production of these border zones. And finally, the third geostrategy is what I call the geostrategy of walls and fences. So we all already know that border fences have proliferated over the last decades, and we have also seen that the EU level, there have been openings to the possibility to use EU funds for supporting member states, for instance, in their border fortification efforts. Apparently, walls and fences are not explicitly prohibited by EU law, even if they pose a number of serious issues with regard to the right to access to asylum, and also in relation to the principle of proportionality. But still, the main argument is that they are not legally forbidden by EU law. Political scientists have well described the ineffectiveness of border fences and walls. They have often underlined the symbolic function of walls and fences. But if we look at border walls and fences from a legal point of view, again, we tend to replicate the traditional Westphalian image of the border by interpreting walls and fences as a typical expression of the state prerogative to demarcate and secure its borders. And indeed, very often the erection of new walls is actually politically justified by making reference to warlike metaphors. Think, for instance, at the role that the image of migration as an hybrid threat has had recently in the European Union in order to justify the fortification of certain sections of the EU borders. But the legal justification for the erection of new walls and new fences is usually found in the traditional conception of territorial sovereignty. And these largely overrides all concerns of the human costs and proportionality of these geostrategy of border control. But very often, my impression is that we tend to forget that wall and fences must be understood as a component of a more complex architecture for the regulation of human mobility. They are not just meant to block cross-border mobility altogether, and even less to protect the territory, as in the traditional argument is often said in the traditional argument for just the erection of new walls and new borders, and new barriers. Sorry, but they are used to create the time space which is necessary for the functioning of the technical and legal infrastructure of the contemporary border regime. They are used to actually channel cross-border movements towards specific crossing points, and those in this way facilitating the extraction of data, the extraction of information from individuals, data and information that actually feeds surveillance system, the surveillance assemblage of the border regime, and the EU border regime in particular. So this is my take on the three geostrategy of the contemporary border regime. I would now turn very briefly, actually, I don't know how much time is left for my presentation.
15 if you want. Do not worry.
Okay, great. So I will now turn to the EU Pact and try to say something on the way in which the reforms that have been recently approved and are set to be enforced for the next. Yet the way in which this package of reforms that we call the EU Pact, the new EU Pact on Migration and Asylum, will in many ways confirm and reinforce the different logics of these three geostrategies that I have just briefly described. These can be seen, according to my point of view, in three main respects. First of all, in the intensification of the member states' capacity to extract data and information from individuals, migrants, asylum seekers moving across the EU borders and across the EU territory. Consider, for example, the cooperation obligations that have been introduced and will require, I'm thinking here especially about the new asylum procedure regulation, but also the proposed return the obligation will require migrants and asylum seekers to in many ways to surrender their personal data, their belonging, their personal information, under the risk of being subjected to less safeguarded and guaranteed procedures, less guaranteed asylum procedures, less guaranteed and more coercive return procedures. So these will fed into, of course, into the existing databases, into the existing surveillance, surveillance assemblage, but also, of course, probably the most explicit and clear example here is the new pre-entry screening regulation, and so the new with the new pre-entry screening procedure, whose objective is not just unwanted mobility at the border, but also to actually transform that mobility into data and into information which will feed again the EU database and the EU surveillance assemblage. So this will reinforce the digital borders of Europe, the logic, the surveillance logic behind the digital borders. But again, we see that the digital borders need to has an actual spatial projection. It needs to meet the actual individual in order to extract data and information from the individuals. Secondly, the second example I would like to make is related with many of the measures introduced by the EU Pact, which involve an explicit legal manipulation of the EU borders and those creating a new frontier, a new border zone. Of course, the most here is clearly the introduction of a number, potentially 3 extraterritorial procedures, in the sense that these procedures, the screening procedure, the asylum border procedures, and the return border procedures are assumed to take place in areas of the territory which are considered legally outside the EU space, the EU territory. Of course, the legal implication of the implications of the legal fiction of non-entry are potentially many very serious. There are many implications and many serious implications of the legal fiction of non-entry. But I think that here is equally troubling the very symbolic rupture which has been produced by the mere evocation of the idea of extraterritorial processing, of the idea of extraterritoriality. I think that this has had a huge role, for instance, in stimulating the Italian government in attempting to offshore asylum processing and return processing by establishing an offshore reception center, which is an absolute novelty in the history of EU migration policies. So here you see the power of the symbolic power of of the very idea of extraterritoriality in inspiring policies and measures at the domestic level. But many other measures included in the EU Pact will encourage proliferation and a diffusion of borders within the EU space. I'm thinking here of the possibility of subjecting to in-country screening those intercepted within the EU territory in condition of irregularity, or also to the new concept of internal border checks and the associated possibility of carrying out rapid readmissions. I'm sorry if I'm not going to see the measures that have been, because I'm assuming that all of you are more or less aware of I'm thinking, I'm speaking now to the recent amendments to the Schengen Borders Code. So the possibility of carrying out border checks into a more or less wide internal border area, and also carrying out rapid readmissions of those intercepted near these internal borders areas between member states. Is not really clear how large is the internal border area where border checks can be carried out. So the risk is that the internal border will overstretch well beyond the regions near the actual border. Well, such measures, of course, they produce a manipulation of the border. They will multiply, overstretch the border. We will encourage racial profiling and discriminatory police practices well beyond the border areas, strictly and geographically understood. And finally, and then I will conclude. I'm also thinking about the different emergency legal regimes which have been introduced, which will not only allow member states to manage the external borders in crisis mode on a virtually permanent basis, especially because the legal categories like crisis, instrumentalization, force majeure, a huge amount of discretion on the part of member states authorities. But I think that the new emergency legal also foster further fortification and further militarization of the external borders, especially along the Europe's eastern edges. And so we will see that the degree of fortifications of European land, especially land borders, of course, will greatly increase over the coming years, and especially concerning is the the possibility of establishing a, like a of a permanent legal emergency regime at the border, which will make a strong step, which will make many member states make to make a strong step in the direction of an explicitly militarization of their external borders. And we already have many signs pointing in that direction. Of course, the Polish, the Hungarian case can be recalled here, but also I would say again, Italy is another interesting case study in this regard. As you may be aware of the fact that, for instance, all the border infrastructures and reception and detention facilities in Italy have been declared as a place of interest for the national security, and they have been placed under the jurisdiction of the Ministry of Defense. This has been done mostly in order to circumvent the regulations on public procurement up to now, I would say. But of course, my impression is that we are moving in the direction of an explicit militarization of the Italian border infrastructure here. So, okay, I think I can stop here. Hope I've been clear, and also I hope to have respected the time allotted to me.
Thank you so much, Giuseppe. It was very interesting to see your way of presenting the new morphology of your borders, exposing these geostrategies of nodes, of zones, of wall and fences, and to see that it can be deployed in order to understand the provisions of the different instruments of the EU Pact on Migration and Asylum. I have some questions and I have some comments, but I will leave them for the discussion part of this workshop. And I think with the European Pact on Migration and Asylum, we have a direct link to the reflections of Violeta Moreno-Lax. I presented with incorrectness at the beginning of this workshop. She is a Women Foundation Chair of International Law and Director of the LT Center for Fundamental Rights. She is Professor of Law and Director of the Borders Center at the Queen Mary University of London. So many titles, so many responsibilities. And of course, the time is yours now, Violeta, to expose your position regarding the European Pact and the dehumanization that borders endorse. Thank you.
Thank you very much, Marie-Laure. Yes, sorry for the confusion on the, I'm on a transitional phase. So I'm finding my feet at the Hertie School. I started in September. So I do preserve the Queen Mary affiliation, although I am on leave. So yeah, no worries about that at all. I'm not going to be presenting the same paper that I already presented for the series. So I'm moving a bit away from what you already heard. And I'm looking at the manner in which the new pact actually it's consolidating perspectives on migrants and migrant rights that are, to my mind, very dangerous. And so the paper today is called Beyond Victimhood. And what I wanted to highlight is that this movement towards strategic depersonification that I'm going to be explaining throughout the paper today. It's perpetrated not only at the EU level, but also with the help of the ECHR. So the ECHR case law has become very stringent. I think we are on a regressive pathway. And the two movements, so this new move at the EU level towards restricting migrant rights is reinforced and sort of like justified by the ECHR understanding of the court in Strasbourg. So I'm going to be speaking about these three things: victimhood, strategic depersonification, and the figure of the culpable migrant as part of the thickness of borders, which we are discussing in the series. Giuseppe has been speaking about the geographical dimension of borders and law working as an infrastructure that serves as a vehicle to the consolidation of the different geostrategies that he's been speaking to. So I'm going to be zooming into one particular of that strategies, which is the mobilization of law towards the fortification of borders and that consolidation of the geostrategies that have been mentioned. So just to situate ourselves, the new Pact on Migration and Asylum, when von der Leyen launched it back in September 2020, this is a bit far ago in our memories, but the promise was to offer a fresh start and achieve a more humane migration and asylum system. So this promise of enhanced humanity gave the starting point to discussion on the reform of the common European asylum system. This very quickly morphed into a vision of pragmatism. So if you look at the different declarations by von der Leyen and the Commission generally during the time that the negotiations lasted, there is a progressive sort of reduction in terms of the expectations of what this more humane migration and asylum system would look like. The end result is a bundle of instruments that contain fundamental rights clauses, and somehow the merit of this promise of a more humane migration and asylum system, promising that there is going to be adherence to key obligations. But then when you zoom into the operational detail, this is very opaque and somewhat contradictory. And we see this particularly in the provisions regarding the pre-screening, the border procedures, the crisis and force majeure arrangements, and indeed in the instrumentalization package, which is no longer a package, but there are provisions that have survived the latest round of reforms. And Giuseppe was mentioning the reform to the Schengen Borders Code that actually now contains a reference to instrumentalization. All of this in combination make effective protection unattainable in practice for most asylum seekers and refugees. I hope to be wrong, but I mean, I think from May 2026, we will have an opportunity to see all of these measures in motion. And I'm afraid that I think I'm going to be correct in this assessment, in my diagnosis. So what I wanted to do now is to actually zoom into two sets of provisions from the new Pact reforms, particularly the Asylum Procedures Regulation and the Borders Procedures Regulation. And when you look at this, you can see that there are diminished procedural guarantees that are adopted under the wraps of technicalities, if you wish. So in order to administer in an effective way the procedural dimension of asylum and border control, there are provisions on the admissibility of claims, on the circumstances under which assessments are going to be accelerated, another bunch of provisions in a different regulation, in a dedicated instrument on border procedures. And what transpires from a post-reading of the provisions in all of this technical detail is a presumed malafide on the part of applicants who somehow, rather than choosing to submit to the Schengen border control rules and the visa regulations and whatever other conditions their entry into the European Union would require them to fulfill, they somehow are depicted as cheaters. I mean, those who choose not to follow the regular pathways and instead take the advantage from whatever cracks there might be in the system and try to access irregularly. Obviously, this hides the fact that there aren't any meaningful pathways for asylum seekers to reach Europe qua asylum seekers in order to obtain international protection. This simply does not exist. I mean, resettlement is voluntary. There isn't really an obligation that has been harmonized in the current rules that would oblige member states to adopt any specific legal pathways to articulate that possibility in law. So it is understood that anything of that sort falls within the remit of discretionality of the member states. And if there are any such obligations as they might freely interpret, this is for them to regulate in their own domestic systems. And obviously, there are only tokenistic examples of states being semi-generous. I mean, if you think of the evacuation plan for Afghanistan in 2021, right after the withdrawal from the UN troops and NATO troops, that lasted for a few months. The places there were absolutely limited, and the gap between the places that were offered and actual needs was huge. But apart from this, there are just a few other mechanisms of this sort. If you think of the Sant'Egidio community in Italy and the humanitarian corridor that they still have open with Libya, we're talking about a handful of evacuation opportunities for people in very dire circumstances. Other than this, there aren't really any opportunities for anyone to spontaneously try to embark on a regular journey and reach Europe. So it means that in 90% of cases, people are going to fall under one of these supposedly exceptional categories. So the sheer reality of facts on the ground demonstrate that these supposed exceptions actually turn into the rules that are applicable to most migrants, refugees, and asylum seekers that venture to the external borders of the European Union. And according to the provisions that we now have, procedures can be accelerated on 10 grounds, which is a lot of grounds for something that is supposed to be exceptional. So everyone would probably fall within one or the other of the grounds. Many of these grounds have to do with safer country provisions or first country of asylum or European safe countries or safe country of origin clauses. So there aren't many options for people not to have their procedural assessments and procedural arrangements accelerated when their claims are going to be evaluated. And I am particularly interested in two of the circumstances that may lead to acceleration. So one has to do with the person being considered a danger to national security or public order, not of the member state that they are trying to enter, but generally vis-a-vis all the member states of the European Union, an assessment that I'm not very sure how exactly a border guard can do, because they are not going to know all of the realities at the border or within the territories of the member states in combination. And what is very worrisome is that there isn't really any need for specific proof or a specific procedure whereby this determination is arrived at. It suffices that there be reasonable grounds, whatever that might mean, to consider that the applicant constitutes such a danger. This is taken out of context. I mean, the provision, it's modeled around Article 33, Paragraph 2 of the Geneva Convention of the 1951 Refugee Status Convention. But obviously, the provision there is intended to work as an exception to the principle of non-refoulement, rather than as a procedural arrangement that diminishes the level of procedural protection for the consideration of whether somebody qualifies or not as a refugee. And by the way, as you all know, non-refoulement was first conceptualized in the Geneva Convention as a non-absolute protection. But through the years, we know that through the effect of international human rights law, this principle has now acquired absolute status, if not even jus cogens level. So this decontextualization, this sort of like taking what was supposed to be an exception to non-refoulement that has now been neutralized by the force of the legal evolution of the prohibition of torture and ill treatment in international human rights law, and it's now been reinscribed in this new procedural context to arbitrate who might have what type of protection, procedurally speaking, when claiming to be a refugee. I don't think is a matter of oversight. It's a very conscious choice that the EU legislature is making to decrease the amount of protection and thereby the chances for anyone to be recognized as a refugee. And there is another similar move that is very pernicious in paragraph H. So in paragraph H, again, decontextualizing what was intended as a principle protective of irregular entry and the circumstances on which, under which asylum seekers have to perform those irregular entries is now taken out of context and reformulated to take away protection rather than add protection. So Article 31 of the Geneva Convention, the 1951 Refugee Convention, encapsulates what is called the principle of non-penalization for irregular entry or stay to protect those that, in the majority of cases, as we know, are going to have to perform an irregular entry because they couldn't obtain visas, considering that visas are not available for those in need of asylum. If you remember what the conditions are for obtaining a Schengen visa, one of the primary conditions is that people can demonstrate willingness and ability to return to the country of provenance, the issuing country that gave the visa. And what people need to demonstrate if they are going to ever qualify as refugees is the opposite, that they are unwilling and unable to return to the country of provenance. So basically, you're asking an impossible task of those in need of asylum to both gain a visa for regular entry so that then their claims are going to be assessed through the normal procedure with all the procedural guarantees applicable. And at the same time, if they don't manage to do that, because they will not, if they need to demonstrate the opposite in order to obtain asylum, then you're going to punish them with reduced procedural guarantees, precisely to be able to meet the definition of a refugee. So this is why I was saying these clauses are not the result of an accident. They're the result of a very conscious effort at reducing the level of protection that applies, procedurally speaking, from a sort of technical side that dents away and erodes the actual access to international protection, the substantive protection that comes with that. And the clause reads like this: the applicant entered the territory of a member state unlawfully or prolonged his or her stay unlawfully, and without reason has either not presented himself or herself to the competent authorities. This bit is contemplated in the Refugee Convention, in the 1951 Geneva Convention, but what follows is not, or has not made an application for international protection as soon as possible. However, the border authorities or the asylum authorities might interpret this as soon as possible, given the circumstances of the entry or stay of the person concerned. So again, I repeat, what was supposed to offer protection against penalization for asylum seekers and refugees entry in a country of potential asylum, it's turned on its head to take protection away rather than substantively, procedurally, so as to make the life of those in need of international protection more difficult, because it would be, I mean, obviously all of this generates presumptions and generates burden of proofs that are on the applicant. The applicant will be the one to demonstrate that they had good reason and that they could seek protection and lodge their asylum applications as soon as possible, whatever that parameter might be understood to entail. And the same kind of diminished procedural guarantees apply to those on the border procedure. So on the border procedure, there is a number of reduced procedural protections that apply, and the amount of applicants that can fall under the border procedure is, again, practically the totality of asylum seekers arriving at Europe's borders. So anyone who reaches the external Schengen border of the European Union and presents an asylum claim there will be susceptible of having their asylum application channeled through the border procedure. The same applies to those who might be apprehended either during an irregular crossing or after having been successful in that irregular crossing. So basically the totality, as I said, of asylum seekers and refugees. And if that wasn't detailed enough, even those that have been disembarked on the shores of an EU member state upon rescue at sea, that also, I mean, this category of applicants is also channelable through the border procedure, as would be the applicants that enjoy, that might be relocated under the solidarity measures that we will see if they actually materialized as designed by the European Commission in the new Dublin replacement regulation. But so the main takeaway is that under the guise of a technicality and under the guise of exceptionality, diminished procedural guarantees are going to become the rule for the sheer majority of applicants that reach European borders. And not only are these diminished procedural guarantees a technicality, but they are intended to somehow punish disobedience on the part of refugees and asylum seekers for not choosing regular pathways, as if regular pathways actually existed. This is never told, but we all know that this is the reality on the ground. Regular pathways do not exist. So a mischief on the part of the member states, the absence of regular pathways for the purposes of seeking asylum, again, is turned on its head and pinned down on the refugee. So it is, what counts now is that the refugee is not following regular pathways, without truth being told, those regular pathways not really being in existence. Okay, and this is something that the European Court of Human Rights has not considered an anomaly. So the European Court of Human Rights sort of has shown deference to the member states in the manner in which they have arranged their border procedures and their procedural arrangements. So although what I have shown now are the reformed clauses after the new pact amendments have entered into force, many of these provisions existed in a more relaxed manner, if you wish, in the previous version of the Common European Asylum System instruments. So accelerated procedures and border procedures already existed since 2005, if not prior, right? So the first country that I am aware of that adopted from the Schengen family border procedures was France, and one of the called the airport procedure, right? So for arrivals at the international zone of airports, they had a special arrangement. And although in Amur versus France, the state was condemned for arranging the system in a way that prevented access to the international protection procedure in France. So the case was a condemnation of the French state in 1993, I think, or 1998. I mean, in the 90s, in any event. There is a lot that has happened in the interim. And the European Court of Human Rights now, I think, has started a regressive line and has been decreasing the level of protection that it is ready to accord to asylum seekers and refugees in border situations, not only in transit zones of airports, but particularly at land borders. And so the example that I have here starts with the Ceuta and Melilla cases in Spain, and particularly the Grand Chamber ruling of ND and NT, where the culpable conduct standard is for the first time announced. And what we see is this contract being used to determine on the merits that the claimants could not succeed in their application, because basically the violations of which they were complaining were of their own making, rather than due to the structural lack of effective mechanisms of access, first to the territory and then to the asylum procedure in Spain. The court is super deferential to the states. It accepts the version of the facts of the state, and not only the version of the facts of the state, but the interpretation of both domestic and Schengen law as applicable to this case. So the court not only fails to engage in an effort to establish the facts, ignoring the sheer amount of evidence that is provided not only by the claimants, but also by a plethora of third-party interveners, including the UNHCR, that showed that there weren't actual pathways to access territory, to access the border crossing point on the Moroccan side for people who wanted to access Ceuta, Melilla, and through that the asylum procedure on the Spanish side. But the court also distorts the interpretation of the applicable law, and it sort of accepts the letter of the Schengen Borders Code at a very abstract level. There is a principle in the Schengen Borders Code whereby the principle of non-refoulement applies, and refugees and asylum seekers should be granted access to international protection. I mean, this is Article 14, I think, after the renumbering. But obviously, this is not the manner in which the law is playing out on the ground, in the way in which the Spanish authorities are interpreting the rules in this particular case. In this particular case, as you will know, the case is one on devoluciones en caliente, so the hot refoulements, right? The hot returns without a procedure at the border, whereby the Spanish police, in cooperation with the Moroccan gendarmerie, simply wait for the arrival across the fences of potential asylum seekers, apprehend them, open the back door, and send them back directly without any questions being asked. Whether they are minors or not, it's not relevant. Whether they are coming from specific nationalities that cannot be considered safe countries of origin, it's not relevant. And then it also disregards the situation on the Moroccan side. Morocco doesn't have an asylum law, so it cannot offer access to asylum on its territory, and it doesn't treat migrants and refugees in accordance with the dignity and rights that they would deserve and to which they are entitled under international law. So all of this goes under the carpet, and what the court considers, and I am now reading from paragraph 231 that you see on the slide, is that in fact it was the applicants who placed themselves in jeopardy by participating in the storming of the border fence in Melilla, taking advantage of the group's large numbers and using force. The reference to use of force is very misleading. I don't know exactly what the court has in mind here. It is true that there might have been some stones being used, but on the other side, police was using batons, tear gas, rubber bullets, and at some point even real bullets on the Moroccan side. So if there was any use of force, any violence, was actually on the part of the authorities rather than the migrants themselves. Then the court continues, they did not make use of the existing legal procedures for gaining lawful entry to Spanish territory in accordance with the provisions of the Schengen Borders Code. So the court here is demonstrating that it is ready to take at face value the version of the Spanish government and the letter of the provisions in the Schengen Borders Code. Consequently, in accordance with its settled case law, although no reference to any settled case law is being provided because this is a prime, right? So this is the first time that this unculpable conduct standard is being coined, but somehow to provide a heavier weight to its own words, the court says that there is settled case law on the matter, which is not true. And the court then considers that the lack of individual removal decisions can be attributed to the fact that the applicants, if they indeed wished to assert their rights under the convention, as if this could be brought in doubt, right? So even the court, not only the Spanish authorities, disbelieve the applicants, but the courts as well. So this mala fide appears to be implicit not only in the narrative of the Spanish authorities, but also in the narrative that the court is employing before our eyes in this specific paragraph. So they did not make use of the official entry procedures existing for that purpose, and they were thus, so this lack of individual removal decisions was thus a consequence of their own conduct. And therefore, there is no violation in this case of Article 4, Protocol 4, which is the provision against collective expulsion. So at the end of the day, we see that the situation that migrants face at the border, rather than being construed as a matter of rights violations of a structural character, and one that is embedded at both the level of Spanish law and EU law, the court represents this as a situation that poses a problem for the states. So it is the states and their borders that deserve protection, and it is the state's prerogative to control those borders that is at stake, rather than the rights of those that encounter the state violence with which the state defends those borders. And there is a trajectory that this unculpable conduct standard has followed in the subsequent jurisprudence of the court. So following from ND and NT, we see a number of other cases where this standard has been deployed and it has been transformed. So the unculpable conduct standard in ND and NT serves as a mechanism to disarticulate deservability of protection at the merits examination stage. But then in a subsequent case, MB and RA, we see this being transformed into an admissibility filter, on the basis of which the court decides to reject the case outright without looking into the merits. And this is very dangerous, right? Because you are not only showing deference to the state, but the very violation at the core of the application is being repurposed into the very reason why you are not accepting to look into the merits of the case. So you are generating thereby an extra layer of protection for the state. So the thing that constitutes the violation now becomes the admissibility filter on the basis of which cases are going to be declared inadmissible and unfunded by the court. And the next step in the logical trajectory is that then this unculpable standard is transformed into a justification to deny victim status to the claimant. So Article 34 of the ECHR, which had quite a broad and loose notion of victimhood attached to it when it didn't concern asylum seekers, refugees, and migrants, we see the scope of that understanding narrowing down on the basis of this unculpable conduct standard in the cases of migrants, refugees, and particularly those caught at the border. And finally, and there's the final step that we see deployed in a case that doesn't concern Spain, but North Macedonia, and pushbacks, right? Because all of these are pushback cases. So from North Macedonia, I think it was, to Serbia, it becomes a presumption against the bona fide of the claimant, and now transformed into an extra burden of proof for the claimant to demonstrate that not only they were there and they suffered the violation that they are nominating, but that they are their own person, and so all of this, and that they deserve to be treated as a victim. I mean, there is a number of layered impositions on the claimant that stem from this unculpable conduct standard being turned into a presumption of non-victimhood that makes it very difficult, and will make it very difficult in the future for claimants to succeed in pushback cases. I think, and we already see this in the Belarus pushback cases, that the standard has become very stringent for anyone to really succeed in convincing the court that the Polish authorities, for example, have violated not only Article 4, Protocol 4, the collective expulsion prohibition, but also Article 3, the principle of non-refoulement and the protection against ill treatment. So the pragmatism that von der Leyen was calling for during the negotiations of the new pact reforms has transformed in the ECHR law in this very thick disbelief of the stories and the narratives of the migrants, to the point that we deny them the victim status that everyone requires to access a fair trial and a fair process at the ECHR level. So although people have been speaking about similar malfunctionings in the common European asylum system as a matter of organized hypocrisy, and I think, so I'm drawing from Lavenet. She has a very important article that she published in the Journal of Common Market Studies in 2018, reflecting on what were the reform proposals after the summer of migration of 2015. So if you remember, I mean, this is not prehistory, but if you remember, the European Commission tabled a number of reforms in 2016 that didn't make it to final adoption during the life of the legislature at the time. But this was a serious attempt at reforming the standards and making it all more difficult for asylum seekers and refugees to gain access to protection and to gain asylum in the European Union. And at the time, Lavenet reflects along the lines of this organized hypocrisy paradigm, which is taken from organizational sociology, to explain that what we saw at the European level was an effort to fill the capabilities expectations gap. And this is the gap that exists between declared principles on which organizations are supposed to act and the practical political realities to which they are confronted, and that narrow the scope of maneuver and that dictate the ways in which they actually can function on the ground. And so this gap between capability and expectations is formulated as a byproduct of sincere attempts on the part of the organization at reconciling conflicting demands, those imposed by contradicting normative principles and the technical environments within which, in this case, the European Union is called on to operate. So this gap is, at the end of the day, seen as collateral damage, a collateral unwanted result of the schism between principal commitments and actual practical political resources of the organization, leading to there being incoherences between the spoken word and the actual action. So the discourse and the law and its real application. So for our purposes, this leads to the disconnect between fundamental rights promises that we find not only in the speeches of von der Leyen and others, but also in the letter of the preambles, for example, of all of the new pact reforms, as well as in some of the provisions. These are mobilized at the symbolic discursive level to justify action. But there isn't then, when you look into the very technical detail, a real investment that would allow for the actual materialization of these principles. And we see this in the pre-screening, borders, and accelerated procedures provisions that I showed you before. My dissatisfaction with this reading, which I think was very apposite when first formulated in 2018, is that we are past organized hypocrisy. We are, I think, embracing a very dangerous new form of, I call it agentic depersonification. So this is a strategy whereby I think we are seeing the European Union progressively closing the gap between capabilities and expectations, so between discourse and action. But rather than doing that closure by approaching law to the founding principles and redressing malpractices, so correcting the wrongs that were already there embedded in the system, this is achieved by reformulating the relevant rules and coaching them in technical language, with the effect that the underlying values are dismantled. They are nowhere to be seen anymore. And this strategic depersonification works through this image of the culpable migrant that depicts what I think is a very ambivalent picture of selective agency, combining features that are active and passive at the same time. So the migrant is both a passive object, a passive victim of their own persecutory circumstances, which is what forces migrants to flee from war, from persecution, from state failure, from whatever other circumstance that make life unlivable in a country of origin. But at the same time, they're also depicted as aggressive perpetrators, aggressive trespassers of Schengen borders that would employ force, for instance, as the narratives of the European Court of Human Rights in ND and NT would have it. So that they are the ones bringing upon themselves the very violations of which they are the victims, so that they can no longer be considered victims under the system of ECHR law that is in part absorbed by the fundamental rights scheme under the European Union legal order. These violations are no longer thereby attributable to the member states. The member states have no longer to engage in any effort at correcting these violations, because these are no longer the responsibility. The responsibility lies with the migrants and their bad choices themselves, right? So if they only had chosen to use legal pathways to reach the territorial domains of the European Union and then seek asylum through the legal means that the system doesn't provide but claims to provide, then the migrants would not be considered malafide, they would not be considered culpable, they would not be considered as aggressive wrongdoers, undeserving of protection. And note that this wrongdoing on the part of the migrants as opening the door to a lack of protection is very unique to the migration domain. There is nowhere else in the system of human rights law a space where even terrorists or criminals do not have access to any form of human rights protection anymore. So terrorists, criminals, drug dealers, you have it, whomever might have infringed the law of a state would nonetheless have access to the protection of the human rights system under the ECHR and under EU law. If only the fair trial guarantees of Article 6 of the ECHR system and Article 47 of the EU Charter of Fundamental Rights would be fully applicable to their plight. This is no longer the case for migrants. Migrants have had their victimhood withdrawn. right? Particularly those that arrive at the Schengen borders on foot and try to trespass the fences that might impede access to the territorial domains of the European Union member states. So this is very unique and very selective in its workings, and it only affects particularly migrants, refugees, and asylum seekers. So to bring all the different strands of this in perspective, just a few words of conclusion. I think this new agentic depersonification device that we see adopted by the European forces, I mean the EU on the one hand and the European Court of Human Rights through its very restrictive and retrogressive case law on the other, allows for the construction of the figure of the culpable migrant as one that is beyond victimhood and protectability. So undeservingness is now part of the system on its own right. It is no longer an exception to be hidden and to be ashamed of in a certain way. It is the very mechanism that will filter out unworthy migrants and unworthy asylum claims. This creates the conditions of possibility for new anti-migrant modes of ordering, and othering that Giuseppe was mapping in his paper, and that I think are going to be incrementally developed, considering that now the strengths of human rights have been severed and they are no longer have the same constraining power as in the past. So the disconnection between fundamental rights discourse and migrants' human rights realities on the ground will be exacerbated as a result. And I don't think, again, I'm repeating myself, this is a byproduct of the capabilities expectations gap. It's not a product of organized hypocrisy. It is the product of a very conscious choice in policy design and legal interpretation that the different law and policy makers at the European Union level and within the ECHR system have adopted. So open hostility vis-a-vis migrants becomes not only permissible, but apparently necessary to preserve the borders of the European Union, who are otherwise presented with an existential threat. The sheer presence of the migrant at the border appears to be such. This existential threat calling for preservation measures of the border, not the people affected by the violence of those preservation measures, but of the border itself. So rather than protecting migrants and their rights, and particularly asylum seekers and their access to asylum, and remember that Article 18 of the Charter of Fundamental Rights configures the right to asylum as a legally binding obligation on the member states of the European Union. So rather than legislating in a way and constructing policy in a manner that will realize and maintain the effet utile of that right, the direction of travel, the new trajectory that the European Union has adopted, and with the company of the European Court of Human Rights and its very restrictive case law, is one of protection of the EU border through the negation of the rights of the migrant, whose victimhood is no longer recognized. So I think this is a very worrisome development, one that I think we should be preoccupying ourselves with, and critically so. And I'm thereby very much looking forward to your questions, your observations, and to Marie-Laure, your comments on this. Thank you very much.
Thank you, Violetta, for your in-depth analysis of some elements, provisions of the Pact, and some decisions of the European Court of Human Rights. And we say with Giuseppe how geographic materiality and legal architecture are intertwined in order to expand borders. And with your presentation, we can see how legal architecture is realizing some exceptions to the rules in order to create a thick space that is unreachable for migrants in order to prevent the effectiveness of rights protection for them, knowing the protection that normally should be ensured by international and regional human rights protection instruments. So we have here two dynamics that are combined in order to create what I called an apparatus, a panoptical apparatus at the European borders, and I share your preoccupation of such a move we have, and that is particularly endorsed by the different home affairs ministries of the different member states, and that is apparently supported by the national societies. But I think that we can delve into how law can create some borders, some expanded, diluted borders, when multiplying categorizations of the third country nationals we have on the European territory. And using these categorizations is a way of widening, deepening the borders, making difficult for migrants to access their rights and the right to have rights. But now I'm going to shut up and I'm going to leave the floor to Maria Gega for her presentation. Maria, the floor is yours.
Thank you, Marie-Laure, for involving me in this research project. I'm truly glad to share my thoughts with all of you today and to explore this topic through different perspectives, different points of view. The specific topic I have chosen to address in this context concerns the legal categorization of third country nationals. I found it interesting to analyze how this legal technique contributes to broaden the line of borders, to thicken borders, and more precisely, why it invites us to rethink EU borders beyond the territory. In this regard, we are witnessing a paradigm shift, which deserves to be highlighted. And to begin, a few words must be said about the classical paradigm. We know that every institution is built on the basis of an ambition to protect an interior space, the insiders, by reference to an exterior, the outsiders, from whom it intends to protect itself by means of territorial, legal, or even symbolic borders. The territorial border, in particular, occupies a fundamental place in the collective imagination to guarantee the security of insiders vis-à-vis the outsiders. It is a control instrument, especially in the context of the nation states. Indeed, the rise of nation states as sovereign states was historically accompanied with the political and legal construction of the national-foreigner dichotomy, which has been considered the cornerstone of the nation state. And traditionally, one of nation states' missions is to protect its nationals, possibly against foreigners, as several authors have already demonstrated. This is the argument. And the realization of this mission was ensured by a practice of controlling immigration and territory, and nation states acquired the capacity to regulate the mobility of migrants with respect to their territorial borders. This is the historical classical paradigm. Yet, for approximately 25 years, the Europeanization of migration policies has affected this pattern in unclear ways or with unclear results. On the one hand, as previous speakers have already highlighted, new borders are emerging Borders become more diverse. Immigration control currently involves borders that are digital, smart, procedural, symbolic, but also legal. On the other hand, the figure of the outsider, the foreigner, the other, the third country national has become polymorphic. It is nowadays divided into a spectacular number of categories and subcategories. And the dichotomy between EU citizens and third country nationals, or insiders and outsiders, appears blurred as legal of non-EU migrants proliferate and disrupt the distinctions between legal regimes. These two elements, new borders and legal categories, are intertwined. There is a move from the spatial dimension of EU borders to a personal dimension through the legal technique of categorization. The control of migrants is now carried out in a dual approach. If EU borders are generally thought of in a territorial logic, they may also be rethought in a legal and categorical logic. In other words, legal borders are the result of a categorization technique through which the reality of migrants is captured and shaped. To explain this phenomenon, some preliminary remarks should be made. First, we can distinguish various types of categories which often lead to confusion. There are categories mobilized by the administration, invented by political actors. There are categories constructed by society or by migrants themselves. For my part, I will focus today on the legal ones, the legal categories. And at this point, I have to note that legal categories are defined in legal theory as sets of specific legal conditions and consequences, or as sets of specific legal obligations and rights. If a person satisfies certain conditions, certain consequences will follow. Or if a person meets certain obligations, she or her or he will have access to certain rights. Second remark, we are nowadays faced with a growing multitude of categories that didn't exist before. We can easily admit that no legal system has categorized persons as much as the European legal system. Categorization reaches, in a way, its peak with the EU law. Third, it must be remembered that legal categorization is not neutral. Despite some schools of thought that have disseminated the idea that categories are neutral, endowed with a certain objectivity, eminent authors such as Hans Kelsen and Charles Eisenman have shown that the law and its categories are based on a construction and are imbued with ideology. Legal categories are not a given data that pre-exist the intervention of the authorities, but a construction, a product of political choices. So once we accept this, the instrumental, functional dimension of categories is highlighted. And we can easily establish a parallel between borders and legal categories. If any border, if any territorial border delimits space, it draws an inside and an outside, legal categories delimit personal areas and are as much vectors of inclusion and exclusion. Thus, they operate as borders and may be used to control immigration. Nowadays, they produce effects of inclusion and exclusion in numerous and varied areas. We discern an increased sophistication of the categorization. More precisely, legal categories serve to delimit mobility, to regulate entry, residence, return, and even intra-EU circulation of migrants. But they also serve to delimit rights and essential aspects of human life, equal treatment in social matters, family development, access to employment, etc. Therefore, legal categorization, understood as a technique consisting for legal authorities of distinguishing between individuals in order to delimit their specific rights and obligations, can be paralleled to a factory of borders, fully dematerialized borders. This is ultimately where the paradigm shift lies. The borders have mutated, and in addition to territorial borders, control is also carried out by legal borders, which are generated by the categorization of individuals. Through its high degree of sophistication, it allows for a redeployment. Traditional land borders are extended by new legal ones. In this way, categorization extends control of space to the personal sphere of third country nationals, and while consolidating over time. To demonstrate this, I will analyze three of its dimensions. Successively, how categorization affects the space, the person, and time. I will attempt to present each of these perspectives, and the first concerns the control of space and migrant mobility. The distinction between legal and illegal migrants, and more specifically, the advent of the category of illegally staying third country nationals, also called irregular migrants, are part of a logic of distancing these individuals from the territory, from the EU territory, or even making them invisible in the public space. We know that the power vested in the authorities to exclude migrants from the territory is long-standing. But since the adoption of the Return Directive in 2008, a significant development has occurred in this regard. The power of exclusion is now required to ensure not simply public order, but more generally to ensure compliance with the rules relating to the entry and residence of third country nationals. Irregularity is presented in political discourse as a vice leading to a fight to remedy it because it breaks with the legal channels specifically established for the entry and residence of third country nationals. And with a view to deploying control to its full extent, the authorities are also engaged in the construction of a specific legal category. The category that we call irregular migrants is dedicated to governing the situation of people without a valid entry or residence permit. Regarding the scope of this category, it is remarkable that individuals are concerned on the basis of a single simple condition, A third country national who doesn't have a valid entry or residence document is considered to be in an irregular situation. So beyond the individual who has entered the territory illegally, irregularity refers to someone who doesn't meet or no longer meets the conditions for residence in the territory. And even if the migrant meets the conditions required to obtain a residence permit, he or she must ensure that his stay is formally based on a valid document. Failing this, the individual will be forced to leave the territory, and this is the pragmatic justification of the category. If we shift our attention to the consequences that flow from this category, the official determination of the irregularity requires, in law and in fact, the return or the removal of the individual from the EU territory. And this obligation is imposed on both the migrant and the member state. This is firstly an obligation for the member state itself, according to the LGD and Zaijun judgments of the Court of Justice. The observation of an irregular situation imposes on national authorities an obligation to issue a written decision. This is secondly an obligation for the individual. Once the administrative decision is taken, the migrant is required to physically leave the territory. Thus, through this legal category, the authorities regulate migrants' mobility and ensure their exclusion from entry and residence, as well as their physical removal from the EU territory. In this way, legal categories reinforce territorial borders. And the control extends to the public space as soon as we take into account the effects of the categorization with regard to the migrants who remain, despite law, on the EU territory. While the return is an obligation for irregular migrants, it is well known that some of them cannot be removed or continue to stay legally on the territory of a member state, whether by choice or for other reasons. And in light of the framework established for the return or removal of irregular migrants, it is clear that their presence in the member state is indicative of a legal dysfunction. Various situations, subcategories arise and induce several legal consequences for migrants. The most radical one is that of criminal sanction. The relevance of such a sanction is debated in doctrine as well as in courts. The Court of Justice has framed the practices of member states on this point with the LGD, Ashok-Babian, or Selage judgments. But in addition to this sanction, migrants are also subject to other measures, to an administrative detention, a re-entry ban, a further prolonged imprisonment. Therefore, the consequences that flow from this legal category create a real cycle of coercion and induce in practice invisibility. Invisibility. Why invisibility? Because as several sociologists have showed it, the public space, the fact to be exposed, becomes a danger, a threat for these persons that pushes them to hide, to be invisible. In other words, legal repression is increasing to better deter, monitor, and finally invisibilize irregular migrants. We see therefore the full extent of the exclusion mechanism, the authorities intend to fight the circumvention of the law by the law and by the social effects generated by these rules. And we see how the construction of this legal category, through its conditions and consequences, operates as borders to migrants' mobility, aiming to monitor and control space. The second perspective that I'm going to present puts the emphasis on the person's identity and life. In this perspective, we go beyond the situation of the irregular migrant to understand more generally what categorization does to those who are in a regular situation. Legal categories impose several obligations to migrants and determine which specific rights may benefit from. As persons cannot choose their obligations or rights, the act of affiliation to a legal category may be, in a certain degree and in certain cases, be considered as an assignment of a predefined heteronymous identity, and may lead to a differentiated treatment. Indeed, to avoid an irregular situation, anyone applying for a residence permit in a member state must associate their application to a specific immigration or asylum reason, so that they are necessarily affiliated with a specific pre-established category. Asylum seeker, family member of a third country national, or a highly qualified worker, etc. Categories provide access to regular immigration channels. They are means of enjoying a right of residence and relevant benefits. But beyond this initial choice, the individual's freedom disappears, or it is limited. This is the case because individuals have to choose one between several statuses to which they could, in theory, claim. The third country national is either a worker or a patient or a victim of human trafficking, when in reality they can be several things. This is also the case because legal statuses have not been created to cover all conceivable causes of migration. There is no category for every reason of displacement. Authorities are not adapting law to the new reasons or threats that provoke this displacement. I'm thinking in particular of climate refugees or boat people. It is therefore no mystery that in order to facilitate the realization of their migration project, many people have to adopt a status that doesn't correspond, or only weakly, to their true socioeconomic profile, and can reflect and dequalification in relation to their professional skills. Furthermore, in order to be granted the requested residence permit, the migrant must meet multiple conditions. Legal categorization imposes several obligations to which migrants must comply with, otherwise they cannot benefit from the right of residence. These conditions vary, of course, depending on the categories in question, but the third country national must generally demonstrate their ability to integrate into society, into host society. Sometimes it is required to take the civic integration examination, to adhere to the values of host country, to speak the language, to not represent a threat to public order, etc. So the third country national must fit the legal molds of the categorization while complying with the formal rules and procedures. In short, affiliation with a legal category is imperative. It is imposed on every third country national. Categorization confers a specific profile on the individual in an heteronomous manner, which hinders free will and emancipation. Categories operate as borders to personal identity and produce effects that reflect a form of subjugation. This dimension emerges more clearly when we pay attention to the distribution of fundamental rights. A migrant's affiliation with a specific category is all the more important because it determines not only their prospects for residence, but also the rights they are granted. Every legal category determines which specific rights a person is authorized to benefit from: access to employment, access to housing, family reunification, etc. In fact, not all third country nationals present on the territory of a member state can claim the same treatment. EU law creates gradations, often subtle. As an illustration, we can mention the right of family reunification, which is presented as a means intended to contribute to the creation of sociocultural stability, facilitating the integration of migrants in member states, and which is nevertheless attributed in a variable manner. For example, the highly qualified workers are favored since they can apply for family reunification under flexible conditions. In particular, they do not have to provide proof of a minimum period of residence, while current law doesn't provide any special guarantees for single permit holders or for students, for example, who therefore need to meet the standard requirements of Directive of 2003/86. So assigning a category to migrants may look like a form of power that governs their entire existence and frames their development in society. Overall, categories establish borders that delimit their personal identity and their social life. Therefore, we understand how this legal technique contributes in a decisive manner to the phenomenon of the thickening of borders. To fully grasp the challenges of categorization as a mode of expanding borders, we must not think of it only at a given time, at a given moment, in a static manner, because categorization also operates dynamically. It unfolds through the different stages of a person's life path. Indeed, current law organizes the transitions between legal categories, between legal statuses over. Once affiliated with a given category, migrants cannot switch from one category to another at their will and according to their interests. The most typical case is certainly the process of applying for the status of long-term resident. This category, according to the Directive 2003, always acts as a second stage in the migrant's path. It has a value of recognition, of reward. It is a privileged status, entitling the holder to the most extensive in terms of stabilizing their residence and improving their life. Yet, the transition is not automatic, nor does it follow a necessary continuum. It remains potential and can prove complex. In fact, a multitude of conditions must be met to benefit from this favorable treatment. Residence on the territory of the member state alone, even if lasting, enable access to the solidarity mechanisms within the host society. Conditions must also be met in terms of linguistic knowledge and economic capacity. In France, for example, access to this category requires proof of adaptation to the cultural context, and if the migrant doesn't comply with this requirement, the condition becomes a vector of exclusion. Economic-based conditions restrict access to this status as well. The migrant must be able to demonstrate stable, regular, and sufficient resources. Only individuals whose profile corresponds to these standards of the host society can fall into this privileged category. It is then appropriate to pay attention to the cases when a transition is impossible. It is not insignificant that all EU directives relating to third country nationals include specific provisions concerning the scope of application of the rules laid down and list the different groups of people who are excluded from them. So to continue with the illustration of long-term residents, Directive of 2003-109 expressly excludes from its scope and therefore from the benefits it provides third country nationals admitted to stay for the purpose of studying or vocational training. This incompatibility is not imposed as a logical necessity, but rather stems from a deliberate orientation. It is constructed by law. The absence of a gateway to the category of long-term resident the desire to firmly determine the pathways of achieving the purpose of their stay requires a presence in the member state that is limited in time. It is only through another category, for example, a work-related category, that individuals, as former students, could potentially access the privileged status of long-term resident and benefit from the rights that derive from it. In short, the assignment of a given category persists over time and in some cases can be difficult to change through a categorical transition. Categories are designed to ensure migration control, which can thus take a temporal dimension. In light of the transitions, the categorical grid captures diachronically the life of the person throughout the entire extent of their presence on the territory of the member states. And in terms of conclusion, finally, by studying the legal categorization from this triple perspective, space, person, time, it seems that we can better understand what the law does through this powerful technique, which crystallizes the intersection between legal reality and social reality. We see the distance, the gap between the legal reality and social reality, which deepens when the former ignores the characteristics and social needs of migrants. And we can also see that categorization is driving today a real redeployment of borders. Borders are shifting and transforming, whether physical or legal, territorial or personal. They are multiplying and mutually reinforcing each other through a phenomenon of sophistication. These are, in many cases, the thoughts I'm submitting for the discussion, and thank you very much for your attention.
Thank you, Maya, for your presentation. We saw with Giuseppe how the legal regime is normalizing emergency regimes, and we saw with Violeta that we have an expansion of the accelerated border procedure that is applied with the European Pact on Migration and Asylum. And here we saw that there is a normalization of the exceptionality. And what we can see with you is that we have also, because of the law, through the law, the expansion of the category of irregular migrants, illegally staying third country nationals. And this is a way of thickening borders that is particularly concerning, as there is a top-down permeability. In fact, there is an easiness for a migrant to become an illegally staying migrant, so being pushed away from all the rights he should be entitled to. So we will discuss this afterwards, and I think that what is important with your presentation is how this legal thickening of borders impact on person and in time, and maybe we can navigate such a situation looking at what migrants can do, what migrants did and are doing today to occupy, like Occupy Wall Street. We have occupying migrants in their nodes, in their walls, in their borders of detention, of subjugation, and we can see that with Paolo Ciotita. Paolo Ciotita, the floor is yours.
Hello, everyone. Good afternoon, and thanks to Marie-Laure for organizing this workshop. I'm going to analyze the role and the attitude of non-governmental organizations, NGOs, and of people on the move vis-a-vis the externalization of European borders in the central Mediterranean region. I will focus on two categories of actors, NGOs and migrants, and on two spatial contexts, the maritime and the terrestrial. So I will first analyze the relationship between European externalization and NGOs, paying attention to the activities carried out by NGOs and civil society actors, both in international waters and on land, in the Mediterranean Sea between Italy and North Africa, and in the territories of Tunisia, Libya, and Egypt. Then I will address migrant mobilizations and protests in Libya, to point out how migrant agency can trigger solidarity and support from other actors against externalization. So I will now start with NGOs. Broadly speaking, NGOs play an ambivalent role between support and opposition to externalization. And many variables play a role to determine whether an NGO supports or opposes externalization. First, there are the NGO's intentions, their motivations, their more or less political or and critical attitude. Another crucial variable is the source of funding. That is, who are the donors? What are the donors' aims? NGOs working in so-called countries of origin and transit are often funded directly by the EU or by specific member states, that is, by the very same actors that promote externalization, or they are funded by international organizations such as UNHCR and IOM, which in turn are mainly funded by the governments of European countries and other rich destination countries of the global north, which are the main actors of externalization. Only very few NGOs do not receive governmental funding, neither directly or indirectly, and can operate more independently, but never fully independently, because another variable is the place, the socio-spatial context in which NGOs operate. It makes a difference if you're working on land or at sea, in a detention center or in the NGO premises, in an area controlled by the government or by militias, in national waters or in international waters, in the Libyan search and rescue region or in the Italian search and rescue region. So these are the main variables. Now I will make some examples of NGOs' activities and their relationship with externalization. Most NGO activities in Tunisia, Libya, and Egypt are potentially, at least, supporting externalization. They are at risk of supporting externalization, more or less willingly, more or less unintendedly, because what are these activities that they are carrying out? Part of these activities are so-called voluntary return projects. These are clearly part of externalization because people are returned from, say, Tunisia or Libya to their countries of origin. And then, so they are kept away from Europe as much as possible. And then there are humanitarian and development projects that in the donor's intentions are supposed to reduce the factors urging people to embark on irregular journeys to Europe. So any activity that aims at improving life conditions for migrants in a given country of transit or origin, any such activity is meant to make people stay there. It is supposed to make life in that country more attractive so that people are not tempted to take a boat to Europe. And then it pretty much depends on how activities are carried out in practice by the implementers, how projects are actually implemented. And sometimes projects are implemented carelessly, and they result in what I call careless support to externalization. An example is a series of short-term projects that were funded by the Italian government specifically for Italian NGOs to carry out humanitarian activities in some Libyan detention centers from 2018 to 2021. These NGOs accepted limitations from the managers of the detention centers where they were working, limitations that were contrary to humanitarian principles, like giving personal items, not directly delivering these items, not directly to the beneficiaries, to the prisoners, but to the managers of the center. And the managers, instead of distributing them among the prisoners, they sold those items on to third parties and made money with them. Some of these NGOs went as far as to install new gates and fences in the detention centers. So they turned from humanitarian actors to externalized border security agents, because they contributed to fortifying detention centers and to immobilizing people in Libya. Other NGOs, instead, they think they are strong enough to manage their projects in accordance to with their own intentions, not to support externalization, but to only support the right to self-determination of people on the move, even if they accept money from the EU or from European countries or from the UNHCR or the IOM. And then they manage their projects in a more neutral way, in a more conscious way. And then, for example, even information campaigns, so-called awareness campaigns that aim at making would-be migrants aware of the risks that they will run if they decide to embark on an irregular journey. Well, even these campaigns can be done in a way that aims not just at discouraging people, which is what donors want to do, but at providing the entire picture, giving the full set of information, also including the opportunities and entitlements that come with an irregular journey, so the beneficiaries can decide autonomously on their future. So this is a rather neutral stance that some NGOs take. So they provide information, and then it's up to the beneficiaries to decide. And if they decide to travel further to Europe based on the information received by an NGO contracted and funded by the EU, then externalization has failed. But the NGO has not failed. It has accomplished its goal to provide neutral information, knowing that this could result in what I call anti-externalization. But there can be NGO activities that end up opposing externalization, although this is not the aim of the NGO. So anti-externalization sometimes is just an inadvertent side effect of NGOs' activities, a paradoxical side effect of externalization. For example, projects for the cultural and economic integration of migrants in a transit country may end up providing people with the resources required for embarking on a sea crossing, even if this is not the aim of the NGO's project. Example, some NGOs were carrying out livelihood projects in Tunisia that should have helped African migrants to set up economic activities to better integrate in Tunisia, so they would not continue their journey to Europe. The beneficiaries received equipment to start an enterprise. Instead of starting an enterprise, they sold the equipment and used the money to take the next boat to Sicily. So the donors were not happy. The NGOs were not happy either. So the anti-externalization effect was clearly unintended. But there can also be intended anti-externalization, which is normally more difficult on land than at sea, especially in countries with low human rights standards, such as Tunisia, Libya, and Egypt. But there is a good example of intended anti-externalization on land in Gaddafi's Libya. In May 2009, the Italian government started intercepting people in international waters, and then Italian Navy ships pushed those people back to Libya. In Libya, the Italian Refugee Council, whose acronym is CEE-EDIEC, so CEE-EDIEC had just started a project to assist people in some Libyan detention centers as a UNHCR partner, as a UNHCR subcontractor. Some CEE-EDIEC representatives were able to collect the signatures of some of the returned of those who had been pushed back to Libya. So 24 Somali and Eritrean nationals were able to file an application with the European Court of Human Rights. And 3 years later, the court condemned Italy in the Hirsi judgment, which was a huge challenge to European externalization because it put an end to direct pushbacks from international waters to Libya. Now, CEE-EDIEC only understands itself as a humanitarian organization. And it works with Italian government money, with EU money, doesn't mind working with taking EU money or UNHCR money. But there are more politically engaged NGOs which only carry out activities born out of the will to develop counter-hegemonic, disobedient, or even subversive practices and discourses that vocally and effectively oppose externalization. I will only make the example of search and rescue NGOs, SAR NGOs operating at sea. So SAR NGOs, they deploy their vessels and aircraft to monitor the high seas in order to rescue people and bring them to Europe. So they openly defy externalization by trying to reach migrant vessels, not only before people drown, but also before the Libyan Coast Guard arrives, and by refusing to hand over the rescued to the Libyan Coast Guard, which would bring them back to Libya, and by insisting that the rescued should be disembarked in Europe. And when they can't prevent pullbacks or other human rights violations, well, they try at least to document them, to film them, and document them. And I call their activity counter-externalization insofar as NGOs, they sort of mimic the activities of externalizing states to reach the opposite goal. SAR NGOs are organized and they are coordinated from a centralized base that is located in a given territory on land, but then they are practically carried out in an external setting in international waters. So in order to act against externalization, they are themselves externalizing their action just like states do. Although, of course, NGOs have no territories. Now I will turn to Libya and make some examples of migrant mobilizations in Libya and how the relevant actors were able to trigger solidarity from external actors against externalization, or were able to act themselves against externalization. First example, in 2009, under Gaddafi, hundreds of people tried to escape from the detention center of Gamfuda in Benghazi. 20 people were shot dead by the guards. Many more were injured. The others were put in isolation cells. The world didn't know. So the detained people started a collective hunger strike while in detention. And then they managed to use a hidden phone to send text messages and video messages to send documentation of what had happened to some journalists abroad. And so reports by international media resulted in in the evacuation of that detention center. Detainees were transferred from that detention center of Gamfuda to another center. And from that center, many eventually managed to escape. Now, let me stress that reaching out from a Libyan detention center is far from being easy. It's very difficult because normally all phones are confiscated and people have no way to communicate with the outside world. But migrants sometimes manage to smuggle a phone inside a detention center and hide it, and then they share it with other detainees until the phone is found and confiscated. So this was an example again from the Gaddafi period, but similar dynamics can be increasingly observed in Libya in recent years. And since 2017, there have been protests in many Libyan detention centers, with mobilizations including hunger strikes, refusal of healthcare, concerted noises or shouting, seizure of guards, and so on. And the requests included the end of punishments, such as isolation, which is a specific, particularly hard kind of detention. Improvements in food provision, provision of healthcare, medical evacuations for serious medical cases, the possibility to register with UNHCR for all asylum seekers, evacuation from Libya, cancellation of deportation schemes, because Libyan authorities often deport people to other countries, admission to voluntary repatriation schemes for those who want to go back home, transfer to safer detention centers, or the full release from detention, of course. And these are the requests that are normally made by people who engage in protests in detention centers. So some mobilizations were at least partly successful. So with protesters' requests were at least partly met because they were able to reach out to external actors who were able to then pressure the relevant authorities, like in the case of the Gamfuda detention center that I mentioned before. But another example from another Libyan detention center shows how migrants sometimes are able to reach their objective directly without the help of solidarity actors. The Tajura detention center was located in a military complex 12 kilometers east of Tripoli. And in May 2019, during the civil war, this military complex was hit by an airstrike. No one was injured, but migrants were afraid and asked for evacuation. No one cared until in July, another airstrike came, and this time 53 migrants were killed, 87 were injured, 500 detainees survived. But the UNHCR was only available to transfer only 70 of them. Only those 70 people who they consider to be the most vulnerable. In fact, they were all equally vulnerable because they were all exposed to the airstrikes in the same way. So the survivors, 500 people, they rejected the UNHCR proposal to transfer 70 of them, and they started a hunger strike. And in the end, they managed to leave the center because the guards eventually let them out. And then what they did was that they started a long march, 12 kilometers until Tripoli. So they marched for hours and hours until they reached the gathering and departure facility managed by the UNHCR in Tripoli. And there the UNHCR was almost forced to let them in because there were bombings out there. So in this case, solidarity among the detainees resulted first in a tolerated mass escape from the detention center, and then in an act of forced solidarity by UNHCR. And in this way, migrants could act directly against externalization. Of course, externalization also means relying on the fact that people will get stuck somewhere while on their way to Europe. And Europe and international organizations like UNHCR will do nothing to help them out of the situation and reach a safe destination in Europe. But migrants took the initiative and were partly successful. At least they were allowed to enter the UNHCR facility and leave the military complex where they were exposed to airstrikes. The last example is the movement called Refugees in Libya and its transnational support network called Alliance with Refugees in Libya. The origins of refugees in Libya can be traced back to the 1st of October 2021, because on that day, Libyan authorities carried out an unprecedented mass raid in the Tripoli neighborhood of Gargaresh. Hundreds of private houses were stormed. Over 4,000 people were randomly arrested, but thousands of others gathered in front of a UNHCR building in Tripoli. And they organized a permanent sit-in there. There were people from other neighborhoods who feared that the same thing would happen to them. And there were people from Gargaresh, from the Gargaresh neighborhood, who had avoided arrest. Within a few days, they gave themselves a name, Refugees in Libya. They created a Twitter account, a Facebook account, and a website. Their public protest went on for over 3 months until the camp was evicted in January 2022, and hundreds of them were arrested during the eviction. And during those over 3 months, those activists, those people, refugees in Libya, were able to get in touch with European and international activists from different organizations and from different movements, including Mediterranean Saving Humans, the Alarm Phone, and others. And this generated an informal solidarity network from European organizations that was initially called Solidarity with Refugees in Libya, and then it was renamed Alliance with Refugees in Libya in August 2023. And in the first period, from October to December 2021, while they were still protesting outside the UNHCR premises in Tripoli, Solidarity with Refugees in Libya collected money and sent money to refugees in Libya for them to meet their most basic needs. They provided advice. They also, Solidarity with Refugees in Libya, this solidarity network, also decided to amplify the voice of refugees in Libya through their contacts with news media and other civil society actors, in order to make this voice from Libya heard among wider international audiences. Solidarity with Refugees in Libya also tried to pressure relevant authorities worldwide with protests and public demonstrations, asking these authorities to respond to the requests of refugees in Libya. The spokesperson of refugees in Libya, David Yambio, eventually crossed the sea himself and reached Italy in 2022. He has lived in Italy since then. He's still very active. Together with the Alliance with Refugees in Libya, he aims to stabilize the movement both in Libya and in Europe. The aim of Refugees in Libya and the Alliance with Refugees in Libya is to transform isolated, ephemeral initiatives into a stable, more durable movement. Previous migrant initiatives were more informal, had less international visibility, and did not last long. They ended at the end of each specific mobilization, because people then went each their own way. Refugees in Libya instead tries to offer a stable, durable presence in Libya for all those who arrive in Libya and would like to mobilize by protesting and seeking support. And in Europe, the Alliance with Refugees in Libya aims to become a stable and durable international partner for refugees in Libya. And it also aims to become a platform for all those who manage to leave Libya and reach Europe and would like to offer their support from Europe to those who are still back in Libya. And if I have 2 more minutes, I will just conclude.
Yes, you have.
So concluding thoughts on counter-externalization. So when SAR NGOs based somewhere in Europe deploy their ships and aircraft to international waters, they sort of mimic what Italy and Europe do with externalization. Italy gives patrol boats to Tunisia, Libya and Egypt for them to patrol international waters and chase migrants, boats, and pull them back to North Africa. The EU sends Frontex airplanes to spot migrant boats and then asks the Libyan Coast Guard to send its patrol boats to pull people back to Libya. Then SAR NGOs respond by deploying their own ships and airplanes to do the contrary and to prevent all this from happening. When migrants in Libya reach out to journalists when migrants in Libyan detention centers, reach out to journalists, activists, or diaspora groups in Europe and North America to ask them for help. They do something that is comparable to an act of externalization. They externalize their action outside Libya to ask for support against the externalized European border regime, like European governments do when they reach out to the governments of countries of transit and origin to ask for their support in containing unwanted migration. And when the Alliance with Refugees in Libya responds from Europe to the migrants' calls from Libya and provides support to refugees in Libya, solidarity is externalized from Europe to Libya. It travels from north to south to oppose European border externalization. So while European governmental actors of externalization transfer funding, equipment, and know-how to Libya and other North African countries to enhance migration and border controls, in this case, it is civil society in Europe that transfers funding and know-how to migrants in Libya for them to resist externalization. And that's it. Thank you.
Thank you, Paolo. It was just fascinating to see the thinking of borders in the other way around. And I think particularly interesting this way you put it, that there is an externalization because migrants ask for help from Libya to Europe, expanding they're asking of help outside the country. And I was astonished by this forced solidarity the UNHCR was prompted to offer because of the mobilization of migrants. So we have to think outside the box in order to expand such solidarity, so such humanitarian borders, but not in the sense that humanitarian actors are involved in the externalization architecture of the different member states in order to prevent migrants to arrive to Europe, but to offer more solidarity to expand the idea of an ethics of hospitality. Well, we have some minutes left, maybe some energy also. So I invite you to write down your question or observations in the chat, or even better, you could switch on your camera and switch on your microphone and raise your virtual hand in order to ask some questions or to make some observations to our four tremendous speakers. But meanwhile, you are gathering all your comments. I'm going to ask, I'm going to be really brief, even though I have many comments and many observations. I'm going to refrain myself and to ask only one question to each of you, because I think it was genuinely very enriching workshop. The first question is for Giuseppe. I think that when you are talking about the geopolitics, the dynamic of geopolitics of walls, fences, nodes, and zones, you offer a way of understanding the continuity, the network that is grasping how the territory, the externalized, internalized territory of borders. And I wonder whether if with your way of understanding these dynamics, you can grasp the continuity that is created in particular where the Schengen border codes and the European Pact on Migration and Asylum between the internal borders and the external borders of the European Union. It's not an easy question, I know. Second question for Violetta. In fact, it's very difficult to have some comments because I totally share your point of view. I think there is a will of political leaders of Home Affairs Ministry to make migrants far away from their rights. And this is prompted in a disinhibited way, so a decomplexed way of ensuring that what I'm used to say, migrants are not subject of law, but object of domination. And I wonder whether if you look into Article 6 of the Universal Declaration of Human Rights and Article 16 of the International Covenant, because there is this right to be recognized everywhere as a person before the law. And maybe this rejection of the victimhood of these migrants facing so violent violations of the human rights is not a denial of such right to have rights as it's recognized by the group on enforced disappearances. To Maria, one question. You described the categorization, and I think that there is like a sophistication in the different requirements migrants have to fulfill in order to obtain a legal status. And I wonder whether if you have some insight on the current examination of the recast of the long-term residence status directive. And if you have some insight, I would be very, very interested. And last, for Paolo, it's not, you are a sociologist, I'm a lawyer, so I'm quite in an uncomfortable domain, but I wonder whether how you obtain all this information regarding the mobilization of migrants in Libya, because we know it's very difficult to obtain some insights. So how do you achieve to obtain such information, maybe from Libyans who arrived or from migrants who come from Libya to Europe who succeed? But well, this is the first point, how you obtain this information, how you can gather it, how can you explore it and exploit it. And the second point is how migrants, whereas they are in detention centers in Libya, achieve to organize some mobilization in different centers at the same time. So how they manage that. So it's totally incredible. So there are my 4 questions. And no, there is no question on the chat. So you can answer them in the order you want. Maybe Giuseppe.
I will let Violetta answer first because she has to leave.
Yeah, sorry.
In a few minutes.
Apologies.
Sorry, I didn't see that. Excuse me. So, Violetta, you can have the floor. Sorry.
Thank you. Thanks a lot. It's been a very rich session. Thank you, Marie-Laure, for the suggestion. I haven't really considered how the denial of victimhood actually might in itself constitute a violation of the right to be recognized as a person before the law. I mean, this very right doesn't exist in so many words in the ECHR. But it would be important as a doctrinal argument to perhaps take this into consideration when developing the paper further. So we do not have the same, so there isn't an equivalent of Article 16 of the ICCPR in the ECHR, but there has been sometimes pronouncements in cases that I think have to do with either the right to life or Article 3. I think in euthanasia cases and in other areas where there might be wording similar to the right to be recognized as a person. So I will have a look at that. And there is a question from Silvia Morgades. Hi, Silvia. On whether the culpable conduct standards that I mentioned was used as an instrument to deactivate desirability of protection under ND and NT, and then in subsequent cases it's been developed. I have just very quickly checked, and what has happened. So she's asking whether the other cases mentioned a violation of Article 3, or if only a violation of Article 4, Protocol 4 was considered. And the thing is, so for example, in NA versus Macedonia, the court dismisses allegations under Article 3 of the treatment endured by the applicants in Greece, and only adjudicates the case under the scope and under the angle of Article 4, Protocol 4, and Article 13. So the prohibition of expulsion, of collective expulsion, and then the right to an effective remedy, but ignores complaints under Article 3. And the same happens in Nabucchi or Nabushi versus Spain. So although the claimant complains of a violation of Article 3, this isn't taken into consideration. So there is a back and forth between the allegations by the claimants and the court in the different cases. I mean, we have seen the court doing this in other situations where they think that, for instance, in intersectional discrimination cases, if the person says there is discrimination on grounds of gender and race, we will see the court saying, okay, I'm going to approach the claim only from the perspective of gender and leave aside the perspective of race. Or some other times, if there are Articles 2 and 3 engaged, sometimes the court would say, I only look at this from the angle of one of the two provisions, I solve it in this way, and I just leave the other aside. So this is what we're seeing happening in the pushback cases, that claimants are trying to harness the force of both Article 4, Protocol 4, and Article 3, and sometimes the court is deactivating one of the two provisions and focusing the reasoning on only one of them, and then dismissing the case on those grounds. So I haven't yet fully made up my mind as for how exactly this is even possible, because if you are claiming a violation of one of the provisions, it should be looked at from that perspective rather than, you know, reshuffled into something else, particularly when absolute rights are at stake. But this needs further attention, I think. We need to keep digging in this area to see what it means and why the court is considering that this is a proper way of interpreting the ECHR in this domain. Thank you.
Thank you, Violetta, for these precious insights. So, and if you have to leave, I totally understand. Your schedule must be very overloaded at the moment. So thank you so much for your presence. It was a great honor and a tremendous pleasure. Thank you, Violetta.
Thank you all very much. And I mean, hopefully we catch up another time. Thank you.
Yeah, I hope so. Giuseppe, I asked you a difficult question.
Well, you did actually. The continuity between the internal and the external borders. Well, to a certain extent, I totally agree with you. We can clearly see that in the way in which EU policies and member state policies at the domestic level are manipulating borders. We see that there is also an increasing role for internal borders, but also a multiplication of border performances, let's say. So border performances within the territory. So, you know, as I was mentioning, the in-country screening is a case in which you will have the external border performed within the EU territory, with migrants potentially stopped, taken in custody and brought back to border zones or to detention centers. We will see how these will be implemented. But at the same time, I still try to resist the temptation of just saying the border is everywhere. My focus is in trying to to map the specific geography of the new border regime. I do really like political geography, and I do really like the capacity geographers have to stick to the materiality of the space and of the use of space, actually. And so I'm interested in the way in which the materiality and the spatiality of the border is reconstructed through law. And actually, the very fact that the border is not everywhere can grasp it when how much migrants are actually able to escape and resist border controls and border practices. And also, if you think about how much they are actually not just excluded, but also included, of course, in a subordinate way, if you want, in our society, but their presence is tolerated, is, you know, there is space for their inclusion in our society. And so there are spaces within our territory in which the border is not performed, is under performed. You know, I live in a region in Italy, which is Apulia, where we have huge informal settlements, encampments of migrants, with thousands and thousands of migrants living on our territory, contributing to the local rural economy under the eye of the authorities, with the tolerance of the authorities. So, of course, and at the same time, you have hotspots here in Apulia, you have detention centers. So you have places where the border is overperformed, or border practices are overperformed, and regions or places where borders are underperformed. So I'm really interested in, you know, mapping the actual geography of inclusion and exclusion, or the actual geography of borders, in the sense, you know, mapping out the places in which border practices are actually performed, and the places in which migrants are able to resist to those border performances, or places which are deliberately left out of the grasp of the border regime for political and economic reasons. So this is you know, at least the attempt I'm trying to do in, you know, in forcing myself into resist the temptation of just saying that the border is everywhere, that the border is multiplying, but, you know, trying to draw a more precise map of the actual materiality of the border regime.
Thank you, Giuseppe. It was really clear, and the geographic materiality of the borders is not apprehended as deeply as it should by lawyers. So I confess myself that I attempt to see borders everywhere, and reading your papers, I reconsider my position, and I hope I will have the opportunity to delve into such geographic materiality of borders in order to map their presence and the networks that is created to such an architecture. So, Maria, do you have some elements to provide us about the long-term resident status directive?
Thank you, Marie-Laure. First of all, you talked about sophistication of categorization, and I would like to note that when I'm using this expression, sophistication of categorization, I'm referring to two things. First of all, that there is a growing multitude of categories, legal categories. There is a spectacular number of categories and subcategories. And second of all, that categories are used to distinguish individuals in order to confer them specific rights. Nowadays, categories are used in order to achieve several goals, several objectives. They are used to differentiated treatment, to dissuade migrants, irregular migrants. We confer specific rights to attract some migrants, the highly qualified workers. And then we use different rights in order to promote social integration of long-term residents. So this is the two things that can qualify the sophistication of categorization. Regarding to long-term residents, in my knowledge, there are no significant evolutions relevant to categorical transitions. So regarding to long-term residents, there is no much improvement, but it is true that over through years, we are witnessing several improvements in EU law. I think for about the beneficiaries of international protection that were enabled to access the high qualified workers for a long period. And it is only with the adoption of Directive 2021 that they can choose, they do not have to choose between these two legal categories. Nowadays, they can benefit from the two categories, from the two legal regimes. Another example is the beneficiaries of international protection. They couldn't access the long-term residents till 2011. But since the directive of 2011, they can also access to this category. And the last example is that of students, that they can nowadays switch to a category of workers. They can they have the choice to stay after their studies, to remain to the territory of a member state for a certain period, of course, in order to search for employment. So over years, we can say that there are improvements to facilitate categorical transitions, but we can conclude that there is still a significant room to improvement.
Thank you, Maria. And Paolo, the question of the lawyer to the sociologist.
Sociologist and geographer. Yes.
Sorry, and geographer. I'm so sorry.
But I guess you mean the question regarded the part about Libyan, the mobilizations of migrants in Libya.
Yeah, that was the case. I was very interested by the way you documented all that.
Comes mostly from interviews that I carried out between November 2023 and May 2024 with activists, with migrants. So 6 were people who had been in Libya and had crossed the sea and had been participating in mobilizations, and and they are now in Europe. So I met them in Europe, and the others were European activists and some researchers, some journalists, and then also some information drawn from well, for example, refugees in Libya, they have their own website and they upload reports, information, and I also participated in 2 initiatives, organized public initiatives, more or less public. So at least we were partly public. There were closed workshops and public ones and demonstrations. So 2 initiatives organized by the Alliance with Refugees in Libya. One in Brussels at the end of June 2023, and one in Bologna in January 2024. So I met these activists, and there also including people who had crossed the sea from Libya. And yeah, that's it. And the second question was, how can they organize simultaneous protests in different detention centers? Yes, this is something I wrote in the paper. I didn't, this was not part of my presentation today, but it's part of what of the paper. And well, they were able to do this through hidden phones. So smartphones, as I said, are always confiscated when people are arrive in a detention center, but sometimes they find ways to smuggle phones inside the detention center, and then they use them, and they use them collectively often. And then until they are found and confiscated, and then again they have to wait until someone else receives a smuggled phone.
Okay, thank you, Paolo. I see that there is no question, no observation. We passed the hour, so I just have to thank you all for your presentations that were just terrific. It was really enriching and fascinating. So thank you so much.
Thank you, Marie-Laure.
This workshop will be shared on YouTube afterwards, and really deeply, deeply honored and pleased to have you with us all. Thank you.
Our pleasure.